Well, May 29 is around the corner, and a lot of Nigerians are focused on the Election Petition Tribunal. My name is Moses Humphrey. Joining me on the show is Esther Nwachukwu, and today we'll be turning our focus to the Presidential Election Tribunal's rejection of the live coverage of its proceedings. Plus, 1 year after its takeoff, the e-Naira is either being avoided or many are yet to know the first thing about it. Now, what could be worse? More than 98% of wallets are unused. Well, we'll have a detailed conversation on these issues and invite you to join us by liking and subscribing to our pages on YouTube and on Instagram as well. On YouTube, we are Voice of the People TV. That is Voice of the People TV. And on Instagram, it is voptvlive. All right, the Presidential Election Petition Court, PEPC, on Monday, which was yesterday, May 22nd, rejected the application for live broadcast of proceedings on petitions seeking to nullify the outcome of the 2023 presidential election. The five-member panel, led by Haruna Samani, dismissed the request as lacking merit. Now, the application was brought before the tribunal by Atiku Abubakar of the People's Democratic Party and Mr. Peter Obi of the Labour Party. Now, they are both challenging the outcome of the February 25 presidential election. The Independent National Electoral Commission, INEC, declared Asiwaju Bola Tinubu of the All Progressives Congress, APC, as winner of the election. And in its ruling on the application for live broadcast of proceedings, the tribunal said no regulatory framework or policy direction authorized it to grant such a request. And it held that allowing cameras in the courtroom is a significant judicial policy that the law must support. Additionally, the court observed that the request was not included in any of the petitions it was considering, noting that it was only supported by a sentimental argument that the gesture would help the electorates. Well, the panel held that the petitioners, had not demonstrated how broadcasting the proceedings would help their cause. Former President and PDP candidate Atiku Abubakar was the first to request live coverage of the tribunal's proceedings, and subsequently, Peter Obi of the Labour Party also made the same request. And their lead lawyers, Levi Uzoku, a senior advocate of Nigeria for Mr. Obi, and Chris Uche, SAN, for Atiku, argued that the petitions filed to contest the declaration of Tinubu as the winner of the presidential poll were of enormous rational importance and public interest. So we do have joining us to, wrap our heads around this, help us make sense of some of these issues. We have barristers Eze Eluchie and Olayinka Ola Daniels joining us on the show. Good morning to you.
Good morning to you, gentlemen. Thank you for having me on board.
All right. I, had to introduce all two of you together. Now, let me start with Barrister Olayinka Ola Daniels. Now, what do you make of this argument that it's purely sentimental as against what Nigerians need to know? There are arguments that Nigerians need to follow these proceedings as it will help build trust for the judiciary. But here, the judiciary is saying it's a sentimental thing and should not be considered, really.
Well, thank you for the privilege to come up on this topic. First, we must understand that there are rules that is guiding the judiciary. There are laws that is guiding the judiciary. So some things, even before you consider, for instance, you say you want, your prayer is for them to make it public, televised, and whatnot. For judiciary to do that, something must be considered first. the rules have to be looked into first. The laws have to be looked into first, and there should be sort of maybe amendment or sort of legislation on those laws and rules to accommodate such. Having said that, we know that even the one that has not been in the public, that our people use social media, I mean, to spread all over the world, and you don't even have facts or you don't even understand the content or how do I put it now? The understand you don't understand the concept of the judiciary or what the decision of the court. Like what you have seen in the past. You see a judgment from court, then what you see on social media, what you see on papers are different things entirely. The mind of the court are different from what has been spread all over on on social media. So using this, and we know the situation we are in this country at the moment, we know how this particular case is peculiar to us. We know Nigerians are all waiting to see something different. So
All right.
when people are in court and they put up the camera in court and they are sending out information that are not true, they are sending out information that the judiciary has not related to the public. So that alone, for me, from the one, I was part of the advocates of not making it public, that application will not fly.
Okay. All right then. Let me hold your thoughts. I see that you want to say some more things, but let's come to Barrister Eluche now. Do you agree? Do you agree that having cameras in the courtroom would further propagate false information, as people will spread, false news and propaganda? Or are you of the opinion that, if cameras are there and people can follow, people will be able to make their minds on what the judges are saying, what the petitioners are saying, and make up their own minds as against following hearsay?
Yes, let me take up from where my learned friend, the allusion he made. He said Nigerians are used to banding about different perspectives, personal perspectives. That's precisely what an order for.
Barrister Eluche, we seem to be having a bit of a problem with your audio. We seem to be having a bit of a problem. Maybe you might.
How is it now? Is it okay?
Yes, it is. Go ahead.
Let me hold. Yes, from what he was saying, that Nigerians are used to banding about personal perspectives as court's rulings. That is precisely what an order for real-time online broadcast would have solved, because everybody will be watching the precise comments from the judges themselves. There will be no mistakes or that he said, she said. Everybody will be seeing the precise, exact words from the judges and from the lawyers. So the issue of live broadcast would have addressed that problem directly. Now, but to the law which you alluded to, what the law provides is that every Nigerian is entitled to free hearing in a public space. We're not supposed to have secret trials. The issue is now, how do we define public space? Previously, public space meant having the courts in a public, the court to hold in an open, where the public have access. The definition of public, with the IT, internet explosion everywhere, has extended naturally to also include having it on social media, should be broadcast live. So the constitutional provision for cases to be held in public must be expanded to reality, because the reality now is that the definition of public includes having access to, so that everybody in the world, anywhere, can have access. We must be very careful in this country. Our justice system has been too conservative. We are always insisting that every comma must pass through constitutional amendment. Every full stop must pass through constitutional amendment. For goodness sake, if our constitution provides that a trial must be held in public, what does public mean? Does public mean a room where anybody has access to? And you know that in this kind of matters, where you have every Nigerian voter interested in it, do we want everybody to come to Abuja and storm the tribunal premises?
Barrister Eze, according to
Yeah.
Justice Samani, he said that the request for a live broadcast of court proceedings has no utilitarian value, and that he
Good.
also stated that it has no provisions in statutory books. According to him, he said that there is nowhere in the
Good.
Constitution and the Electoral Act for televising court proceedings. He also went ahead to say that live broadcast of proceedings is a judicial broadcast. That's basically what he said. So he said, we cannot permit a procedure that dramatizes the court's proceedings based on the premise
Good.
that was given according
Yeah.
to what is in the Electoral Act and what is in the Constitution. Would you say that they were right in not letting the public view of what is going on within the Election Petition Tribunal Court? And you talked about the fact that Nigerians want that sense of transparency, that is
Yes.
because of the kind of participation that was involved in the just concluded elections. But if the court
Yes.
has made all of these based on what is not in the Electoral Act and what is not in the Constitution, is it possible that the judge, like he rightly said, live broadcast of proceedings is a judicial policy? So can't they make it a mandate based on the judicial policy to do a live broadcast rather than declining completely?
With all due respect, my position is that the judges who made that ruling were wrong, because the constitutional provisions is very clear that every trial must be held in public. So the issue now is, what is the definition of public? And I'm saying that previously, public meant just having a room where those who are interested in the proceedings can walk in and observe what is going on. But for an election, a presidential election that had over 20 million voters, you simply cannot expect 20 million people to come to Abuja. So the meaning of public, that is held in public, under the Constitution, must be extended to mean people having access to listen and watch, which includes a live broadcast. So it is not really a judicial pronouncement. It is already what is in the Constitution. That is why I started by saying our justices have to be very proactive. This era of being conservative must be ditched. You cannot say because there was the public then meant only in one room, then that is what public must continue to mean. This is what has led us to have so many constitutional amendments from a document of less than maybe 300 pages. The US Constitution has only been amended about 25 times, 200 years. But Nigeria, we amend ours over 25 times in 1 year, because we have people who are insisting that every word must be amended as each day turns. No.
All right.
Public, for goodness sake, means access by everybody. And access by everybody is occasioned now by live broadcast.
All right. So
The
I'm coming
judges,
to.
sorry, let me just conclude.
Okay.
The judges don't realize that we now have technology that mere buttons on my shirt, even the glass ring, can contain cameras. So despite what they are saying, I assure them live broadcast will continue, because the reality is that public have access to hear. Thank you.
All right. Now let me come to Barrister Oladaniels, and well, you've listened to your colleague. How do you interpret the every trial must be held in public? What's your interpretation of it? And also,
All right.
would phone lines, will mobile phones be allowed in court? Because if they are, people will still, make recordings of proceedings, and then it will be hearsay. It will be then we'll have issues of edited videos, or these videos are fake, these videos are not real, and things like that.
Okay, first of all, when we talk about the public that the Constitution made provisions for, when you say public, court is a public place. except when it comes to probably juvenile that, okay, the court decide to move the court to its chamber. Court is a public place, and that has defined the public. So anyone that wants to see I do not see the court buying or telling anyone that wants to watch a proceeding not to enter the court, except the court is overcrowded and it's not convenient, and the court just want to manage the space.
Well, then
They
again,
cannot.
then
Now,
again, sorry to interrupt you. Sorry to interrupt you. I just want to, get these thoughts out. Then again, if everyone who is interested, and we do know that all Nigerians are interested in this case. If everyone decides to throng the courtroom, don't you think there'll be chaos?
Exactly.
Oh, hold on, sir. Reason why you have representative. For instance, we have different parties that are in court today. All the party members cannot be in court. That is why they have the principal members of the party to appear in court. All Nigerians cannot be in court. They can't be in the courtroom to watch proceedings. Some people will be in the courtroom to watch proceedings. What the judiciary is guiding against, it says not allowed to be televised. Now, my senior learned colleague made a statement of saying that it should be extended to the social media, to the television and all. But I do not agree to that, because it's very good to define this and to draw the lines. If we say that, okay, we are rigid and that some things should be considered without amending the laws, I'm afraid that may be calling for anarchy. Because if we do that at every moment, we all know what that may give birth to, which we cannot afford. Now, the court has said not to televise. So yes, that reason when you go to court, the court will say, please switch off your phones or put it silent, because they don't want all that distractions. So now, if you then use maybe the pin or the glasses, whatever, to record anything, and the court is not aware of that, the court, to the extent of their own understanding, to the extent of their ability to curb excesses of the public, they have said no televise. So that if you go ahead and you do that, it's at your own instance, because the truth is, after the court adjudicates over this matter, they're still going to go to the chamber. Go to the inner and look at this before they come out to give judgment. So irrespective of what the cameras are doing, the cameras will not be there when the judges are writing their opinions or writing, their submissions. So even at that, it's still going to come out to say this is so, whether they even use the board to come what I have said about the way public perceive things. As in, this is not a stadium, this is not a crusade, this is not, no, I do not. And again, to protect the judiciary, to protect so many things about it, is not a secret court, yes, no doubt about that. Some things that must be protected. For why would people they go to the lawyer, they go to court to find maybe resolution or to find solution to some issues. If we then make everybody comes with television and they broke. So I remember even one of the judgment, one of the lawyers of I think one of the parties was citing O.J. Simpson's case in the U.S. And it has to be made clear. O.J. Simpson is in the United States of America, not system in the judiciary. So we can, and we also know what happened in O.J. Simpson case. How some rumors flying, how some truths were captured by the media, and also what happened during that case. So we can't, and this particular case we are talking about is peculiar. We can't afford it. It's a public place. They have not denied anybody from accessing the court. To witness, to watch proceedings, but not to televise. That is what the court is against. That's what court wants to protect
All right. All right.
The judiciary.
All right, Mr. Olayinka Daniels, we'll come back to you and Barrister Ezeluche. Nigeria's president-elect Bola Tinubu on Monday urged the Presidential Election Petition Court in Abuja not to harmonize the three pending petitions challenging his victory. Mr. Tinubu's victory at the February 25 presidential election on the platform of the All Progressives Congress is being challenged in three separate petitions pending before the court. Atiku Abubakar of the People's Democratic Party, Labour Party's Peter Obi, and the Allied People's Democratic Party filed their petitions in March to challenge the outcome of the poll. The petitions, containing largely similar complaints, accuse the Independent National Electoral Commission (INEC) of widespread irregularities during the conduct of the presidential election. Atiku and Mr. Obi, in their separate suits, are urging the court to either declare them president or nullify Mr. Tinubu's victory and order a fresh poll. Now, I'm coming to you, Barrister Eze Aluche. This next question is to you. Apparently, yesterday, whereby the APC and the presidential candidate of the All Progressives Congress, who is now the president-elect, is urging the court not to harmonize three pending petitions challenging his victory. Peter Obi is saying that it is either he is declared as the winner of the February 25 election, and Atiku Abubakar is saying either you also declare me the winner of the February 25 elections, otherwise you either nullify the victory of his election and order for a fresh poll. Now, we do know that we have issues already at the Election Petition Tribunal based on the cases already there. Also, something to take note of is the fact that the People's Democratic Party said they have about 100 witnesses to testify against the emergence of President-elect Bola Ahmed Tinubu, citing several irregularities across some polling units in the Federation. Also, Peter Obi had said he has 50 witnesses to actually testify in the court that they actually ought to have been the one to win the just concluded the February 25 general elections. With these pending motions, do we think that they have the substantial evidence to prove to the court or the judges at the Election Petition Tribunal that this election that was just concluded there should be a rerun of it?
Well, thank you very much. With regards to the refusal of the fact that the APC is against joinder of these petitions, it's quite unfortunate. The court has about 180 days, the tribunal has 180 days to listen to all these petitions, and one similarity, one commonality of all the petitions is that they are all seeking that, or they are asking the court that the APC candidate did not win election and or is not qualified to even contest. So this will minimize time, save time, since all our petitions are basically asking for the same thing. So in the areas of similarity, the courts can and should join these petitions because it will save the time of the court, save everybody's time, and a request by the petitioners. What I was even expecting from the parties is that they should have had preliminary objections. They should have had preliminary applications, such as for the court to urgently address two key issues, because these two key issues will have been: one, is the candidature of the APC candidates valid in the first place? Because there's, unluckily enough, there's a Supreme Court judgment which is going to address that. And secondly, is the APC candidates qualified to contest? Because if the court had addressed this as preliminary applications, perhaps we wouldn't that Bola Tinubu and Shetima do not qualify as candidates. Then the issue of going further and wasting, even swearing in and wasting a further number of days would have been addressed. But to go into this application and then 100 witnesses, 50 witnesses, when pertinent fundamental issues as to the validity of the nomination of the so-called president-elect is still at stake, it's unjust and unfair to Nigerians. The international community is watching, and they'll be making mockery of the Nigerian judicial system. We're not the only common law country that does election petitions. They do the same thing in Kenya, in Zimbabwe, in South Africa, and for goodness sake, within 2-3 weeks after elections, every judicial issue is resolved. All this talk of 1,500 witnesses, where are they coming from? Are you going to bring a witness from each of the polling units?
All right.
And usually that is because our courts always say, yes, there was irregularity, but you've not proved it substantially impaired on the elections. You don't have to bring from every polling unit. That is why our justice system has to be proactive. We cannot continue to be an embarrassment to the lawyers in Nigeria and to the international judicial process.
All right, Barrister, Barrister
Yes.
Olayinka Daniels, this next question is for you. Okay, so we have this case at the moment, right? There are actual cases at the Election Petition Tribunal. It's quite an unfortunate scenario because there's a feeling that Nigerians feel that it is important for these cases to be quickly resolved before inauguration. Inauguration is a few days away, right? May 29 is just in a few days. Preparations are already in top gear for it. And some critics believe that the court is taking its time. It's been lackadaisical in its attitude, in its aura to resolve the petition at their table, quickly resolve it, and let Nigerians move on and know what is next. Do you think that a court is being lackadaisical? Do you think they're being so unnecessarily slow in resolving most of the issues pending at the Election Petition Tribunal?
There's a saying that when you are not informed, you will be deformed.
Okay.
The public, majority of the public are not informed. They have allowed sentiment, they have allowed emotions to cover their reasoning. When you talked about court being slow about this matter, now, and the Labour Party are come to say we need 7 weeks to do this, to prepare our whatever, to put our house in order. Is that the court? That is not the court. When lawyers bring different applications to court, is that the court to probably delay justice or delay so many proceedings? Is that the court? That is not the court. Number 2, if the law had made provision for 180 days to look into election matters like this, is the court the law that make those number of days? Now, as you can see, when the Labour Party now is asking for such days to prepare their, to put their house in order, their witness, whatever they need to bring to the table. Now, what do you expect? Will that cover the number of days left for the inauguration?
But actually, let me ask you, for a party that wants this whole process expedited, one would think that they already had all that was required of them present, available actually to expedite the process, knowing that May 29, which is there's a controversy around the fact that once the president-elect has been inaugurated, there's a possibility that there may not be any more transparency, or possibly the judges may be induced with the federal might. So one would think that the Labour Party asking for 7 weeks to prepare whatever it needs to prepare in terms of presenting its evidence at the court would already have had that, while they're clamoring for the expedition of the process at the Election Petition Tribunal.
If you have a matter in court, it be you to prove whatever you have. You must bring all your evidence in place. You are coming to court. All that should have been, put in place even before you start the matter in court. Have everything ready to pursue your matter. Not when you then start, you now realize, oh, this evidence is not here. No, sorry, one of the respondents needs to give me some evidence and I do not have them yet, so I need so time. So saying that if the court, if the court had done what they were expected to do, that this will not happen. No. You know why? Because you don't want to go to court and make fool of yourself and lose your case. You want to establish your case. You want to prove your case. So all the evidence you can lay your hands on, you need it. And that is why Labour Party has said, okay, we need so time to all this. They have not done anything.
All right, Barrister Oladaniels. Let me stay with you now. Barrister Oladaniels. And we do know that elections were held on February 25. This particular election was held on February 25. And it took so long for the court to even, to come together and say, oh yes, these are the judges. Let the presidential elections petitions tribunal start to seat, announcement of judges and all of that. It took so long up until May, before, and we know that May is the handover date. And, a lot of Nigerians have been clamoring for the going through the court cases, the election cases before May 29. Now, in as much as the parties on their own are trying to get more witnesses and all of that, and that would take 7 weeks for some, longer time for others, which will drag, if care is not taken, drag into the end of the year. But why do you think? Now, let's also join this to the fact that the court is saying they cannot join suits. I mean, the parties challenging the legality of the president-elect cannot join suits, and we know that joining suits will facilitate the cases in court. I mean, even if they take time to get their witnesses to court, when the suits are joined, I believe that would facilitate the case in court. Now, saying no, we will not join suits, wouldn't that drag this even more than it's been dragged already?
Correct an impression. Is it possible? The 7 weeks that the Labour Party has asked for is not to be able to start their case. It is the period they believe will be sufficient for their 50 witnesses to be brought before the court. They've never said that they're not ready, their case is already ready, but it's the time they expect it will take to present their witnesses and evidence before the court. I just want to correct that impression, and I believe also the same time frame will also apply, or even slightly more, since they have more witnesses, will apply to the PDP.
So my colleagues, let me also just, before I go on the question, let me quickly say this, sir. If you have a case, sir, and your witnesses are not ready, tell me you are not ready, sir. If you don't have your, we know that it's not that they have not started their case. Nobody is disputing that. We know that. No.
Okay, we're not in court, gentlemen. We're not in court. So let's.
Sorry.
Let's
okay. All right. Let's leave that. Let's go back to the question. Now, some of us, from day one, you see, this whole election petition tribunal, whatever, didn't just start. We don't know what happened from 1999 to date. So, well, thankfully that people are aware today, considering what used to happen. And that is why the noise is so massive today. Some of us, we've been an advocate of 30 days before swearing in. Some of us, we've been asking for that. That look, whatever the tribunal want to do, even all the way to Supreme Court, please do it in 30 days before inauguration, so that we don't come. We've had instances in where people, even whether governors, senators, they had been elected. In fact, some they've been sworn in and all that, and the court came, and we still know what happened thereafter. How the court changed, the game. So we've been asking that, look, we need to stop all this. Let us have all this sorted before swearing in. We are advocates of that. Having said that, if that law has not been changed, if that has not been amended in our laws, then there is nothing anybody can do. The court cannot help it.
All right, Barrister Olaika Daniel. So let's look at the scenario. Like I said, these open live broadcasts of events transpired in Kenya. We could see how that actually helped the democratic process. One would think that since Nigeria is at the crux of its democracy, we're trying to level up with our international counterparts who are practicing the system of government, that this would be one of the process through which the Nigerian government would prove that they have elevated themselves, all right, from the old ways, or let me not use the word old ways, from the fixed or stifled way of doing things, and prove to everyone that indeed the judges at the Election Petition Tribunal intend to be as transparent and objective as possible. We saw what transpired at the Oputo panel, the kind of massive participation that Nigerians had in watching all the court proceedings. It's almost like when you're watching a football match and you have nations across the world supporting their clubs, their various clubs or football personalities, and it's being telecast on every medium and every live channel. There is that concentration. Everyone can see when there is something misplaced. There is even a rewind with the VAR to see where somebody did not do something right. Don't you think that this will be one of the reasons why it would have been good? All right, it would have boosted the confidence of Nigerians on the Election Petition Tribunal judges if they have approved the live broadcast. Let's just say it's not in the Constitution, neither is it in the Electoral Act. But don't you think this would have boosted Nigerians' confidence that these judges intend to carry the people along? Everyone would know that they have to do things the right way, not about dramatics or theatrics, but that this would have helped the process and given Nigerians the kind of confidence that they need, that little confidence that they need in our judicial system.
Absolutely. Absolutely. I'm with you 100%. Yes, it would have happened, and that would have, as it would have been, the trust of the public and things would have been better. Absolutely. But then, that cannot be done in perpetual. That cannot be done on sentiment or because we want to meet up with the international world. And so what we should do, irrespective of the laws, irrespective of the rules, irrespective of the guidelines. That is why you go to court, you have civil procedure, you have civil procedure rules that guide the court, that guide the bench and the bar in their proceedings. So you cannot say because you want to do this, then you did not follow due process. Then when it then happens, all of us start coming back to shout, to say, see what they did. No, what we are saying, we want this to happen. Yes, we are asking for it. But what we are asking for is to follow due process. Let us amend all the necessary legislation to accommodate all our requests.
All right,
and I want to believe that the National Assembly, the one coming up, I believe that they will not just go there and drink tea and eat bread, but do what they're supposed to do. Okay. The people that are supposed to write and give them bills to sponsor, let them consider all these things in their bills so that we can have all this being amended and being legislation on it.
Barrister Eze Eluche, one of the spokesperson or media aide of former President Goodluck Ebele Jonathan wrote a tweet. On that tweet, he said that the Labour Party claims that their mandate was stolen. They claim that they ought to have been the right political party to win this election because they feel that it got a lot of votes. But however, they were like say isolated from participating, and it's taking them 7 weeks to prepare their witnesses. Possibly it means that they're not ready, or did they think that this is a social media call rather than something quite realistic? Are you of that note that the Labour Party seems not to be ready for asking for that period to prepare its witnesses?
Again, I said the issue was not that they are asking for 7 weeks to prepare their witnesses. It is that it will take about 7 weeks for these witnesses and evidence to be passed through, to be brought before the court, to pass through the court because of the court processes. It's already things on ground, and they can easily be marshaled once the court begins. So whoever was tweeting was not properly abreast of the facts. Is that it will take about 7 weeks to pass for 50 witnesses and the various documents to pass through the court. But having said that, we should be very careful about what you see, the problem with Nigeria, particularly when we are the presidential election, this one is the president being sworn in. If we realize that once a president is sworn in on May 29th, he has executive powers over and above all things. Even the tribunal building can be brought down, and under the pretext that they want to build a road through it, or they want to renovate it, and there'll be no more room or no more place for the judges to sit. The parties want to bring in witnesses from abroad. The immigration may frustrate their witnesses because the president, who is now sitting, does not want them. A lot of time, moment a litigant in this case is sworn in as president, we can as well forget the entire process.
So does that validate the call? Does that validate the call from some sectors in the polity whereby an interim government has been asked for in order to prevent what you just mentioned?
Yes, I mean, it need not be an interim government. I mean, when we call names, we begin to have, the question will not rise, is it in the constitution? What is the constitution is that the tribunal can give orders that must be respected. If, for instance, the tribunal says, let me give an example, that, okay, since we're not able to finish these procedures, in the interim, let the Chief Justice of the Federation be in charge of the executive arm in the interim until the matters are finished. It solves it. It's not an interim government. It's just a court order that is being obeyed. I mean, let us have it clear. Because when you now say interim government, you hear people now begin to say, where is it in the constitution? Because Nigerians want to see every comma and full stop in the constitution. But what our constitution provides is that there is a tribunal, and the tribunals can give orders. If in its wisdom, the tribunal says, let's be in charge. Because let me assure you, and Nigerians have to know this, the moment a person is sworn in as president, and he has control of the EFCC, of the NDLA, I wouldn't be surprised if the tribunal judges suddenly begin to have millions of naira in their wardrobes and then the system gets corrupted.
The
fact that the tribunal judges have refused Nigerians access their televised broadcast, and if this thing continues and the president is sworn in, we might all forget it. And that is what will breed these schisms in the society, particularly in this particular election, that the process has been so much proved not to have been smooth and fair.
All right, I must say a very big thank you to you, learned gentlemen. Big thanks to legal practitioners, Olayinka Oladanels and Eze Eluchie. Thank you for coming on the program. We appreciate you.
Thank you very much.
Thank you.
Well, up next on VOP this morning, it's been 1 year already since the launch of the e-Naira, but it's now clear that many Nigerians barely have a clue as to what it's about. Now, how does it differ from the failed cryptocurrencies or even Ponzi scheme? Oh well, this conversation comes up in a short while. Stay with us.